Okay, just covering some of the background. So everyone now knows, I don't know if anyone in the globe knows, that 23rd of June we voted in favour as a country of leaving the EU. The result did obviously run contrary to the majority of opinion polls and left the UK in a position that very few people had anticipated. I think that was including the government and certainly the bookies. The expectation was that UK voters would have chosen to remain and we would have been left really as a kind of business as usual. Given the outcome of the Leave vote, we do have a significant amount of speculation, which is, those of you who are following this very closely, daily. But given that we had David Cameron stepping down, Theresa May and the new government coming in, that we then had the flurry about whether or not the referendum result was binding, and timescale challenges, what the post-Brexit UK is going to look like. So the way we're looking at this is that your task force does need to be up to date on the movements that are in government and in the EU, because it's very difficult for them to operate in a vacuum, and given the facts that are, the speculation is sort of changing daily, they do need to be well briefed on all of this. Particularly with the financial markets, you know, some moves by the Leave campaigners backing down a bit on their pre-referendum promises, and obviously the value of the pound is something that's been watched closely. A key question that we have already been asked on multiple occasions is about compliance. So a crucial point to note is that the EU laws and regulations do continue to apply in the UK until the official exit terms are agreed, and even through that notice period they still apply to all of us and to businesses. Where there may be some transitional periods that will span on potentially, but critically, and if I can make that very clear, there is a lot of speculation also, and I have been in discussions with people speaking about, could I ignore compliance for a period of time because I'm unlikely to be taken to court in the time that it will take to exit. You just can't take that risk. So if I can make that very clear just now, tempting though it may be in relation to certain regulations, it does not free us from the EU regulatory backdrop. But that's obviously relevant for things also from a state aid perspective. You know, the legal position remains clear. We comply until terms of exit are finished. Okay. Right, let's look at the Scotland position. Again, a number of questions have come to us from clients, and your Brexit task force is going to be looking at all of this. Scotland did vote overall to remain in the EU. There was actually a smaller turnout in Scotland, contrasting with the overall vote to leave. So therefore we've got statements from the First Minister indicating that the prospect of Scotland leaving the EU is democratically unacceptable. The result has led obviously to not just speculation but moves towards the potential of a second independence referendum, and she has indicated that it's clearly an option that requires to be on the table and is very much on the table. And those of you based in Scotland will be aware that there is a survey underway of the general population on the potential issues, or trying to work out really, I suppose, a poll on which way it would go. The consensus is, I think, that another independence vote is probably unlikely until it's clear what the settlement is that the UK has negotiated with the EU. Westminster permission would be required to hold the referendum, and obviously some of the recent opinion polls have suggested that although there was an initial spike and move towards a greater vote for independence immediately after the referendum, that seems to have gone back towards where the polls sat before, and there are various questions still circulating around currency, oil price, etc. The Scottish Government's stated position is that Brexit is detrimental to the Scottish economy, and a consultation paper which was published on the 23rd of August had concluded that by 2030 Scottish GDP would be between 1.7 billion and 11.2 billion pounds per year lower than it would have been if the UK didn't leave the EU. So that could, overall, that's about a reduction of somewhere between 1.3 to 7.9%. Questions have been asked about whether or not the Scottish Government could block Brexit, and certainly the First Minister has been very proactive in meeting representatives from the EU institutions and other member states seeking to protect Scotland's place in the EU. On the 25th of August, Michael Russell was appointed Minister for UK negotiations on Scotland's place in Europe. The extent, obviously, to which Scotland will be able to influence the Brexit negotiations is at this stage probably unclear, and France and Spain had made it clear previously that they would oppose the EU entering separate negotiations with Scotland. Currently, if Westminster decides to pass legislation that will affect issues under Holyrood jurisdiction, the Scottish Parliament needs to be consulted and pass a motion of consent first. Therefore, it's foreseeable that Scotland would not grant consent to any legislation that would pave the way for a Brexit, such as a repeal of the European Communities Act of '72, and the First Minister had also stated that withholding the consent was also on the table. Westminster could, of course, legislate without getting consent, and there was a Welfare Reform Act in 2012 passed, despite the Scottish Parliament refusing to grant consent. So there are different examples, and it will remain to be seen how the Scottish Government will influence the negotiations, but it's expected, obviously, that we'll see legal and political levers pulled on both sides. So if we look next at the Article 50 petition, the timescales and mechanics will obviously be key to our chocolate and waffle-making business that's EU-wide. Brexit is still fundamentally a legal process. It's clear that the process for leaving the EU will require us to formally trigger Article 50. The wording of the legislation is that that's done in line with constitutional arrangements, which I'll come back to, because we don't have a written constitution, and therefore the question of how that was going to be actually triggered has become the subject of some debate. Government solicitors have confirmed that the Prime Minister will not be triggering Article 50 before the end of 2016, and there's now some speculation around the timing of the French and German national elections, and what impact that may have on timing. We've seen, obviously, the Berlin position for Angela Merkel, and her intention now to stay. She remained, instead of going to the UN in New York, she remained locally. So obviously there's been some speculation around what the German position will be, and actually who will be negotiating with the EU come later in 2017. There are also doubts been raised about whether or not the Prime Minister alone has the authority to trigger Article 50. We have a legal challenge in the UK courts, with the argument running that only the UK Parliament has authority to trigger Article 50, which would, in theory, give MPs a chance to derail the Brexit. It's difficult to see how that would play out, given that we act in a democracy and they are representative of their constituents, but clearly that's the position that's being discussed at the moment. There's a full hearing in the High Court scheduled for mid-October, and there are indications that that may be passed on to the Supreme Court before the end of the year, which could again affect the timing of any Article 50 trigger. We also have legal proceedings which have been raised in Northern Ireland by members of the Legislative Assembly, and as with the English High Court case, they are seeking to challenge the UK Government's authority to trigger Article 50. Another claim has been raised by a Northern Irish campaigner, and their contention is that Brexit would result in the UK being in breach of its domestic and international treaty obligations under the Good Friday Agreement. There have also been recent reports that a group of British expats have now banded together under the name Fair Deal for Expats. They are planning to launch a legal challenge in the General Court of the European Union and they are going to be challenging the Commission President Juncker's presidential order, which has prohibited EU commissioners from negotiating with the UK over Brexit until Article 50 has been triggered. So the group is currently raising money for their challenge through a crowdfunding website, but essentially their argument is running that Juncker did not have authority to close down those negotiations, and they are wanting some certainty given their status in the EU has not been secured at this stage. So whatever happens in terms of timing, the Brexit advisory group within any corporate is going to have that clearly in their thinking, particularly when business plans are being sorted, contracts are being looked at, etc. So once that has been triggered, there's a maximum of the 2-year negotiation, unless all 27 member states and the UK agree to an extension. And there's also been some question marks about what happens if the UK changes its mind, and you'll all have seen the discussions round should we have a second referendum actually covering what the details are in advance of the trigger, etc. So it all remains to be seen. This next slide sets out the main players in the negotiation on the UK's future relationship. The key point really to note, and you'll see we've kind of picked little bits out, but these are not S&W comments, can I hasten to add, these are picked from the press and from what they have said. So we have not made any, in our apolitical way, we have not made comments on either way. We're advising on the facts as we know them. But both sides have expressed pretty extreme views, and there's been a significant amount of posturing in the press. So the key figures really on the UK side were campaigning obviously in favour of Brexit, with the exception thereof obviously Theresa May. And then on the other side, Michel Barnier has been appointed as the chief negotiator in charge of leading the Commission Task Force, it's nappily titled Commission Task Force for the Preparation and Conduct of the Negotiations with the United Kingdom. So the FT headline at that stage was that the UK had reacted coolly to Michel Barnier's Brexit appointment, and I think he had been dubbed the scourge of the city after rewriting the rules for financial services. We also have Sabine Weyand, a German national and trade expert at the European Commission, who will become the executive deputy Brexit negotiator in this task force to handle the negotiations, serving alongside Barnier. Interestingly, the Commission and the Council, the European Council, have been involved in a bit of a tussle over who's going to lead the Brexit negotiations. This is important, obviously, because the Commission, realistically, the Commission is more likely to take a harsher stance than the Council. The Commission's legal services opinion is that only the Commission could be appointed as a negotiator. The European Parliament agreed with that and voted for the Commission to lead the talks. However, the European Council has now appointed its own chief negotiator, Didier, who will lead a special task force. So it's not quite clear who's going to be the main point of contact for the UK government during the negotiations, but actually the personalities at this stage may actually, when the negotiations start, they may actually become quite important. And clearly underneath all of this is the civil service on both sides that will actually be doing the detailed negotiations. The EU itself has got no shortage of skilled trade negotiators, because the UK has relied on the EU to do so, so we are actually at a bit of a disadvantage there, and there's a talent shortage, and the media has been reporting, and followed it closely, that the department now that's been created, the Department of Exiting the EU, is apparently experiencing some difficulties getting hold of staff who are doing it and want to front the negotiations. We talked obviously earlier about the French presidential election, the German election in 2017. Now that could obviously have an impact on whether it's Hollande and Merkel staying in power, and the tone of the debate is going to be interesting, I think, over the French and German attitudes, because they will be quite key. And also, we've seen significant moves right across different member states in Europe as a result of the Brexit vote. And again, the task force really has to stay abreast of all these developments because they could be key to the outcome, particularly in different sectors. So if we just turn back, those of you who have attended the first will remember this slide from there, but we thought it's useful just to reflect. As you know, our advice, and those of you who have read our briefings, we are quite confident that it will be a bespoke UK deal. But this was the model that was issued in our first webinar, just covering all of the different models. But critically, you know, with all of these, the influence is very limited, and no matter which way people voted, the UK has been an influencer, you know, in European on-regulation, whereas these models really don't give they don't influence the legislative process, and therefore, you know, compliance with European standards and regulations for businesses to benefit in the European market without being able really to influence the outcome of that, you know, is an issue that's going to have to be worked through. Recently, the Swiss and Norwegian states have they've expressed their desire to revise their own EU relationship, and whether they'll end up joining in with the UK negotiations will remain to be seen. There have also been talks in Brussels, but these are not official, you know, from the EU itself, about a bespoke model which reflects a sort of two-speed Europe. And this would allow countries like the UK to rearrange their integration in the EU, and anyone who's read it, it's actually quite an interesting read, and obviously there are significant numbers of papers being issued, but this one relates to the Continental Partnership, and I would commend it to you for a read-through, but it's quite an interesting thought process about how you could realign and rework the relationships across the board. So I'm just going to, now if I can, bear with me. What I'd like to do now is if I can introduce my colleague Liam McLean. Gordon Downey is actually on the line, but he has been in transit. So Liam has kindly stepped in. Liam is also an EU lawyer specialising in EU regulation, and has kindly agreed for a seamless, and so you can have an easy, non-disconnected webinar. Liam has stepped in to do Gordon's slot. So I'm going to hand over to Liam, who's now coming back to our chocolate factory in a bit more detail. So we've covered really broadly what they need to be aware of from a political and timing point of view. And if I can now turn to Liam, and we're going to walk through the legal issues that they're going to have to be analysing.
Thanks very much, Louisa, and good afternoon, everyone. As Louisa mentioned, on the slide you're seeing at the minute, we are revisiting the case study which was introduced in our pre-referendum webinar. We've taken the example of a UK chocolate manufacturer that operates across the EU, and this slide sets out some of the key legal issues that are relevant to a business like that. A detailed analysis of all these subject areas that you're seeing on the screen at the minute is available in the recording of our original pre-Brexit webinar, and as Louisa mentioned earlier, that's available on our website. The second section of today's webinar that I'll be speaking through will consider what key action points the Brexit working group of a business such as Chocolate Factory Limited would need to look at in terms of Brexit-proofing their business. Although, of course, the implications of Brexit for your business are far from clear, there are some key action points that could be prioritised by any business operating in these uncertain times. While, as Louisa's explained, the precise details of the terms of a Brexit will be worked out in the coming months and years, businesses likely to be affected should start to identify potential areas of risk and impact now. Businesses should, of course, also assess how Brexit will impact on their staff and their customers. So, first of all, exposure to EU law. An important initial step might be to review your business's exposure to EU law generally. In other words, this might be an opportunity to review legislation that stems from the EU and how this affects your sector or industry, or perhaps even your business individually. It's important to understand how that legislation might change in the future when Brexit occurs. There may be losses, but there may also be opportunities to change the current legislative framework for the better. Whilst the government is preparing to trigger Article 50, UK businesses should be doing the same. Brexit working groups, or indeed their external advisors, may want to draw up a list of applicable legislation in order to, for example, review what elements of law applicable to your operations is EU law, which has direct effect in the UK, for example, an EU regulation that affects your industry. Legal instruments like that will simply no longer apply post-Brexit. Another area to look at is EU-level legislation which has been implemented in national UK law. This will very likely remain in place immediately after Brexit, for example, if it's part of an Act of Parliament or a UK statutory instrument, although of course the fact we are no longer an EU member would allow a UK government post-Brexit to amend such legislation as it saw fit. After this initial scoping exercise, it might be worthwhile to consider which legislation in your sector, business or industry it would be wise to seek to protect, or which legislation that you've needed to deal with up till now, where a change may be beneficial flowing from Brexit. This should help inform any engagement you have with government, either directly or via trade bodies, for example. Indeed, a number of industries have already expressed their views to the government that they should seek to advocate a low-cost, easy visa regime if the European principle of the free movement of persons is lost. If this is an important point for your sector, your Brexit working group may want to follow or echo similar views. Second of all, reviewing your workforce. Businesses also need to assess their exposure to future changes of the free movement of persons. This, for example, may be particularly important for organisations with cross-border EU operations, businesses that rely on seasonal staff from the EU, or highly labour-intensive or service industries that benefit from the EU workforce being able to move to the UK easily. The first thing to note is that EU nationals' right to reside and work in the UK will not be impacted until the UK has definitely left the EU, which, following on from Louise's discussion of the Article 50 process, should not happen for at least 2 years from now, and indeed will likely be even further in the future. However, this may change after Brexit, and many EU nationals in anticipation of this might, for example, seek to leave the UK before the Article 50 negotiations have concluded. It's therefore important to communicate regularly with all your staff and perhaps provide them with appropriate information and support. The third point we're going to look at is commercial contracts, and this is another key action point your Brexit working group could consider now. Many businesses will review existing key contracts to ascertain how they might be affected by the UK no longer being a member of the EU. For example, it might be wise to consider whether any contracts could be frustrated by the knock-on effect of Brexit. The example we gave in our contracts briefing was that an agency contracted to place workers at short notice in different member states may be unable to fulfil its obligations if the free movement of persons no longer apply to the UK. Furthermore, certain contracts contain a provision whereby a significant change in law or a material adverse change in law, which arguably, for example, could be the repeal of the European Communities Act 1972, could give parties the right to renegotiate or terminate that contract. It might be wise at this stage to look at your suite of contracts and consider whether you might be able to rely on such a clause if there's a contract that's problematic or you may need to get out of, or indeed might there be a risk of one of your counterparties relying on such a clause to justify a breach or a termination on their part. From a more practical standpoint, it might also be important to look at your key contracts and consider whether the commercial terms need to be renegotiated in light of the UK no longer having access to the single market, in light of other changes that might be triggered by Brexit. Key points to note here, for example, are how might those contracts be affected by increased trade barriers. If the UK no longer has access to the single market post-Brexit, imports and exports will be affected by tariffs, which may lead to increased costs. Also, when negotiating future contracts, you might need to consider the extent to which prices should include or exclude any new taxes, duties or other levies that other member states or the UK may implement on imports and exports. And also, on the practical commercial renegotiation of contracts, you might need to consider the impact of the weakened pound. Imports and raw materials are likely to be more expensive, so consider perhaps renegotiating contracts denominated in pounds. Also consider how best to allocate the risk of fluctuations of the pound's value in future contracts. Another point for your Brexit working group to consider is the ongoing compliance costs with EU law. It might be wise to review what authorisations your business will need in order to continue to operate in other member states. For example, under current EU directives, financial services firms authorised in one member state can conduct business in any other member state without any additional authorisation from the host state where they're doing business. This is often referred to as passporting. This is likely to fall away once the UK leaves the EU, meaning that if your business is involved in regulated financial activities, for example, you'll need to seek new authorisations to trade in other member states. IP rights is another key area that may be affected by Brexit. Here, similar to the commercial contract review you might consider doing, your Brexit working group could review any key intellectual property rights that are important to your business. In particular, protection offered to trademarks and registered designs under the current EU procedure might not be recognised in the UK post-Brexit. Currently, UK businesses can register trademarks and designs either with the UK Intellectual Property Office, which only, of course, offers protection in the UK, or with the EU Office for Harmonisation in the Internal Market for a community trademark or a community registered design, which by contrast offers EU-wide protection. The latter is, of course, more attractive at the moment, but that protection may fall away post-Brexit, so review whether any trademarks or designs will need to be protected here in the UK. Another issue that is often looked at along with IP rights and contracts is data protection. Your business will, despite Brexit, almost certainly need to ensure compliance with the new European General Data Protection Regulation, which is known by its acronym usually, the GDPR. Given it's likely that, again, as Louisa mentioned, that there will be a 2-year period during which the UK will remain part of the EU after having triggered Article 50. The UK will still be an EU member state on the 25th of May 2018 when the GDPR enters into force. The new regulation contains some pretty onerous requirements, so it's important that your business is geared up for complying with the GDPR, even if it might not be enforced in the UK for very long. Even if the requirement to comply with the GDPR did fall away after the UK leaves the EU, if your business has staff or customers in other member states, then you still must comply with the GDPR. This may in practice require the UK to implement very similar laws to the GDPR in order to meet the EU standards, regardless of the constitutional or trading position post-Brexit. On a related matter, the European Commission has also recently approved EU-US Privacy Shield, which is a new framework for transatlantic exchanges of personal data for commercial purposes. It's likely that once the UK leaves the EU, it will need to agree to a similar framework. This will obviously be material to your business if you have links with the US. In terms of EU funding, your Brexit working group should also review whether your business, or indeed key customers or suppliers, receive funding or other incentives from EU programmes or initiatives such as Horizon 2020, the European Regional Development Fund, and for those in the agricultural world, the Rural Development Programmes, which are supported by the Common Agricultural Policy. Their terms of funding or incentives might change, or they might fall away entirely, even prior to the UK leaving the EU formally. The UK government may step in to fill the gap, but again, it's far from certain whether this will happen and how it will take effect. Clearly, this could have serious practical issues on how businesses fund themselves. In respect of litigation and arbitration, it's important now to review your exposure to ongoing cross-border litigation or to any pending EU-wide litigation that you think you might be affected by or involved in. What will happen to such litigation post-Brexit is still to be determined. Therefore, to relieve any uncertainty, it might be important to do all you can to obtain a judgment or settlement prior to the end of the Brexit negotiation period. If that's not possible, it may be worth considering alternative dispute resolution procedures which can provide more certainty. Whether decisions of the UK courts will be enforceable in other member states post-Brexit is also unclear. Again, alternative dispute resolution may provide more certainty regarding overseas recognition and enforcement of the outcome of any litigation or arbitration. In terms of maximising your your Brexit working group's ability to influence matters, it's really important to follow industry collaboration in Brexit. Trade associations and industry-wide groups may already have done a lot of the Brexit-related work for you. However, as lawyers, we would put a little red flag warning in that and note that any participation in industry-wide collaboration or exchange of information should be done strictly within the parameters of competition law compliance. And then finally, in terms of these key action points your Brexit working group might want to consider now, it's important to follow what the government is doing in your sector. The government and Parliament will be holding sector and subject-specific consultations to gather views and formulate policies on Brexit and associated matters. Indeed, some of these have been launched already. For example, a parliamentary inquiry on the implications for UK energy policy and a similar inquiry for UK climate change policy. Also, Louisa mentioned the special Scottish position in the Brexit debate, and the Scottish Parliament has also launched an inquiry into the EU referendum and its implications for Scotland, and has called for evidence on the impact of the UK's decision to leave the EU on Scotland. Just one such example of a sector-specific programme that's in place already is the UK-EU Life Sciences Transition Programme. This is led by the UK-EU Life Sciences Steering Group, and was recently announced by the former Life Sciences Minister George Freeman. The group reports into a government body, the Ministerial Industry Strategy Group, and I think across a lot of sectors you might see these combined efforts between major industry players, trade bodies, and indeed the government trying to work out how Brexit should be approached and how we should best deal with the consequences of it. And
sorry, I think yes, that sort of concludes our formal part. Suffice to say that the Brexit Task Force Advisory Group within any organisation has got plenty to be doing. They will need to then feed back in, for example, to risk registers. They will need to be updated. You know, all the wide parts of the business need to be drawn in and represented in the group. But we do think that if they have not been set up already, they certainly should be in short order. And an immediate impact, obviously, is looking at things like risk registers. And as Liam's identified, there are multiple areas which need to be looked at in some detail, so that people are poised and ready to move when this becomes more certain. But also it is a time where, from the perspective of lobbying, this is a time where, you know, I would say not only the Holyrood government, the Westminster government, but there are people with their ears open and willing to listen. So if there are critical issues for your business or organisation, this is the time to collate them, as would our chocolate and waffle making business be doing, and work out what those impacts are and ensure they are directed through the correct channels. So if we look now at, that's really the conclusion of that, we'll open the floor now to questions which can be submitted into the chat box, and I see that some of them are coming through, so I can see some are coming in. I'll come back to that, but if I could just mention again, we do have these in-depth bulletins on our EU referendum webpage, so please do feel free to log on to them. We've got packs of information and they're being updated, so different practice areas are working on it all the time, you know, and obviously advising clients. We're also happy to answer specific questions, and clearly we've been doing a number of training sessions in all our different practice areas, and that follows up from the work that we did in the lead up to the Scottish referendum also. I should maybe just from a housekeeping point of view just mention that you know, this does form part of CPD for those of you who are, need that for your Law Society of England and Wales and Scotland. Okay, so if I maybe, I see we've got a question in on customs tariffs. So if I maybe take that one, Liam, if that's, yeah. So this is whether, I'm just reading it out. So customs tariff, will all UK products face customs tariffs? Yeah, actually, this is probably one we can bounce between us two. I'm just thinking that is definitely something that we would need to be reviewing as part of our Brexit advisory group.
100%.
Yeah, when we did the previous referendum, we confirmed that there were tariffs and preferential quotes, and obviously for that one it was for chocolate products from outside the EU, and the duties there ranged from 8% to 43%, so it's quite significant as a chocolate eater.
Indeed,
I can say those are significant duties. But Liam, I'm right in saying that a lot of products in third countries are quite low tariffs, is that right?
Indeed, and that's the EU position, that many products coming into the EU face a 0 or a very low tariff. But I suppose the overall point here is the position just depends on what type of deal the UK will negotiate. That's why, exactly as you said, Louisa, it's important to follow what the EU and the UK will negotiate in general, and also in particular any negotiations that the UK does at the WTO in terms of its schedule of concessions, which will reflect the specific tariff concessions that the UK and the EU make with each other post-Brexit.
Yeah, I'm also just thinking if you've got customs legislation, then presumably becomes more relevant as well.
Indeed, it's not just the tariff you need to factor in. You need to remember that, you know, as an EU member state, there's currently very low to minimal customs costs in terms of form filling and your time and your business that is spent dealing with these compliance matters. Depending on the deal that's agreed post-Brexit, that could change. I think, for example, the EU customs form for things coming from out with the Union is 58 pages long. So you can imagine trying to fill in every one of those for every box of chocolate you send into the EU.
Yeah, that would be most
difficult,
inconvenient, to say the least. Absolutely. Yeah, we've got another question coming through, actually, just on the contract piece. So this question relates to the material adverse change clause, and at what point that would become relevant. So I'll just, if I read out the question, it's from what you said on material adverse change clauses, how what arguments could be put against that contract you wanted to remain or keep in place. So I think there, the material adverse change has not happened already. So anyone arguing, if I kind of pick perhaps the background to that question up, anyone who's arguing at the moment that a material adverse change clause has been triggered by the vote, I would say legally I can't see how that stacks up, because we have not had an Article 50 trigger event, and even once that is triggered, there's still an argument that the point where the change occurs is once the new deal is known. Transitional arrangements, yes. There is certainly a lot of discussion in the legal community just now, and again it does depend on which side of the fence people are sitting on, because lawyers being lawyers will argue it either way round or each way round, and really it does depend on whether or not you want to remain in a contract. If both contracting parties want to stay in the contract, then absolutely, it's not an issue really. You can work round that. Your issue becomes if either you or a party you're contracting with wants out of the contract. I think that's going to become the issue, isn't it, Liam? Yeah.
And I suppose another point on material adverse change clauses, when perhaps you do get to the bit in Brexit occurs and you want to claim a particular legal change has, created a material adverse difference to your ability to perform the contract, it's going to need to be specific. You're going to need to be able to point to, a specific legal obligation or a specific legal change that's been affected by Brexit, and explain why that has changed the contractual position. Just a general, Brexit has occurred, very likely won't be enough.
Yeah. Yeah, exactly. I think that's a good point. And again, that's probably where, just picking up on the diligence that any task force in an organisation is looking at just now, these are the points of diligence about where are the risks that weren't there before for these contracts, where might someone argue against it, and whether you want to look at, certainly the key ones. I've got another question actually that's coming through off the back of this one, is about, from a reasonableness point of view, how much work should this task force, should a task force that, I'm assuming the question that's coming through is from an organisation which hasn't necessarily got a Brexit task force set up yet, and therefore how much work do you need to be doing? I mean, I would say we recognise from a legal point of view, everyone has still got their day jobs to be doing. This is an extra bit on top. But it's definitely worth, I think, dusting down risk registers. And I would say, depending on the number of key contracts that you have, most people will have somewhere between 10 and 30 contracts, which are absolutely business critical, and as a minimum they should be looked at, I would be saying.
Certainly.
Yes.
Certainly.
Okay. I'm conscious of time. We're coming up to the end, so I'll maybe just take one last question, and then those of you who have emailed in specific questions, we will come back. But the last one is just on the interplay between the Scottish referendum and the EU membership, and I think there I can answer. So basically this is about Scotland's status. Scotland at the moment is in the EU through the UK. It doesn't hold a separate membership. To apply for member state status, Scotland would need to be an independent country to apply for that. So I hope that answers that question. As far as I am aware, there has not been a route to retain Scotland's membership without reapplication. So I'm just conscious that's us now at 2:15. Can I thank you for your questions? We'll come back separately, as I mentioned. Can I thank you all for attending today and for listening? And just another flag, there is webinar 1 still there. So if the Brexit Advisory Group wish to have a listen at that, please do feel free. Thank you all. Bye-bye.
Thank you. Bye.